edited minutes for February 10th, February 12th, and February 26th. Mr. Ranking Minority Member.
Mr. Chair, I move that we approve the wonderful minutes for the dates that you had mentioned.
We only do this to watch you turn red, Cheryl. Is there a second on the motion? Second from Representative Wilborn. Is there any discussion on the minutes? Okay, seeing none, you've heard the motion from the Ranking Minority Member to approve the minutes for February 10th, 12th, and 26th. All those in favor signify by saying aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. The minutes are approved. And I found out today you actually don't need a second on approval of minutes for some reason. So learned something new today and then did it wrong anyways. The next order of business is a hearing on Senate Bill 451. Mr. Revisor, would you mind giving us a rundown on that bill?
Mr. Chairman, members of the committee, Mike Heim with the Revisor Statutes Office. This bill amends a section of the Campaign Finance Act dealing with treasurer reports, and the amendment is on page 2. Currently, each report required by the state shall state, and it's got a list of things there. Number 9. When our expenditure is made by payment to an advertising agency, public relations firm, or political consultant for disbursement to vendors, the report of the expenditure shall, and current law is, in detail name each vendor and the amount, date, and purpose of the payments. And that's stricken and would provide instead product services provided by each vendor, including the date and purpose of the expenditure.
Okay. Are there any questions for the revisor on the contents of the bill? Okay, seeing none. Thank you very much, sir. I'm opening proponent testimony on Senate Bill 451, and our first listed proponent is Mr. Clay Barker. Welcome back to the committee, sir.
Thank you, Mr. Chair. Clay Barker, General Counsel, Kansas Secretary of State. This bill was brought to the Secretary of State by a group of political operatives who wanted to make an improvement, a small change to the Campaign Finance Act, and because the Public Disclosure Commission was a little chaotic this summer, we agreed to be a proponent for it. It was briefed to the Interim Committee on Campaign Finance, and the bill was brought. It passed the Senate 40-0. The revisor reviewed the essence of the bill, but currently a campaign must report every vendor it hires, it pays money to and expenditure to the vendor, and lists the amount, date, and purpose, and each of that vendor's sub-vendors. So even if the campaign doesn't have a contract with the sub-vendor, it's supposed to report each sub-vendor separately. And that has given rise to a few problems. First, it's done inconsistently by campaigns. Some treasurers aren't aware of that. Some don't even know their vendor may have a sub-vendor. And that's because the campaign doesn't have a contract with the sub-vendor. They don't have direct, what lawyers call privity. And it makes it hard to vouch for what the sub-vendor did or does, and it makes it hard to enforce for the Public Disclosure Commission because the campaign may honestly report what they think is correct, and there may be a mistake, but then you have to track down who the sub-vendor is and did they tell the campaign correctly. I also learned from some of the piece of proponent testimony in the Senate that wasn't submitted to the House is some vendors are very specialized. They may do one thing, and they do it for Democrats and Republicans together, and they don't want that made public because they feel they'll get caught in the partisan crossfire. Like you're working for Democrats, you're working for Republicans, and where most vendors tend to be public relations people, or they just do one side or the other. So what this bill does is it changes what's reported from the amount, date, and purpose to now it will be the amount, date, purpose, and the specific products or services. Not in great detail, but you just can't put $10,000 for advertising. You need to put a little more detail in there. But there's only one entry for what the campaign pays the vendor directly. And I know many campaigns use different vendors for each product or service. In that case, each of those gets reported. But if you hire one consultant that does all the sub-vending for you, the campaign would only have to report what it gave that consultant, and then all the products and services that are given without having to list each sub-vendor. And with that, Mr. Chair, I'll stand for questions at the appropriate time.
Okay, are there any questions for Mr. Barker, Representative Mosley?
Good afternoon, Mr. Barker. So my question for you, so I work at a digital media firm, and say, for instance, does that include tools? So let's say, for instance, someone hires us to do advertisement, and now we're using like YouTube, or we're using like different things that include like the tools. And then my other question for that, if I may, is like some firms, you pay the firm, but they have someone who's doing like someone else is doing digital, because they might not have a graphic designer there. Someone else is doing, so you might have like a lot of different hands that are subcontracted out for a single project. So instead of having one line, you would like to have 10 lines potentially for all the hands that's touching a campaign at any given time?
Representative, the essence of the bill was just to report the general products and services. You can't do something too overarching like advertising, $20,000, but you didn't need to put each specific item that was funded. It's somewhere in the middle. The bill doesn't go into great detail on that. Now, the original bill used the word report in detail, and the Senate struck that out because they didn't want to go down I think the rabbit hole that you're suggesting could happen, where every little item needs to be reported. But the idea is just report in general. We did this advertising, this was for mailers, this was for products. And I realize that the statute doesn't precisely define that, and if it becomes an issue, that would be something for the Public Disclosure Commission to flesh out.
May I ask one more question?
Go ahead.
Because as someone who's also had to hire people, like the last campaign I ran was like a $10 million campaign. Who's asking for this? Like, what problem is this solving? 'Cause I'm trying to understand why the way that we have been doing it is an issue.
Representative, it was brought to us by a couple political operatives that run campaigns, and that were saying their treasurers sometimes had problems tracking down each sub-vendor. They knew who they gave a check to if they hired a general political consultant, but they couldn't always get each sub-vendor and what that sub-vendor did. And they were concerned about inconsistent enforcement, and that some campaigns didn't even realize they were supposed to list each sub-vendor. They would just list their main vendor, and they may not even realize that their main vendor had hired a sub-vendor. The vendor just saw their job as fulfilling the contract, either by their own actions or by giving it to a sub.
Right. Are there any other questions? Representative Bronk, and then Representative Williams and Simmons.
Similar question. I'm looking for the language that talks about sub-vendors, and I'm not sure I'm getting that from the bill. Are you just using that as an example, or is there something in the bill where we were supposed to report sub-vendors and now we don't?
Representative, currently,
I'm just looking exclusively on page 2, 9.
well, 9 talks about expenditures made to advertising agencies, public relations firms, or political assault consultants, and report such expenditure to vendors. So I'm using the word sub-vendor and vendor to mean the person you have a direct contract, the campaign has a direct contract with is the vendor, and the sub-vendor is the next level down. And currently the law requires that each sub-vendor gets reported as a separate line item, but many campaigns weren't doing that because they didn't understand that that was
I guess that was my question. I didn't see that here. Is that someplace else in the law about sub-vendors?
Sub-vendors was the term we were using, but it's in that subparagraph 9 on page 2, line 20 to 25, which says each such vendor.
Okay, I'll try to read this more carefully, but I guess I wasn't seeing sub-vendors in that language.
And Representative, that may have been part of the problem, is that the Public Disclosure Commission believed that the sub-vendors were supposed to be reported individually in campaigns. May not have understood that.
Okay, you may have just seen the light bulb go off on my face inside my head. And so It's not the law that's necessarily requiring this. It was the commission. That was, okay. I just, everything just clicked into place for me. Thank you. I was confused by the explanation, but I appreciate that.
Okay,
Thanks.
Representative Williams, thank you.
Thank you, Mr. Chair. So this particular piece of the statute, it doesn't apply to political parties, or I'm sorry, PACs? Or does it? Do these changes apply to PACs, or is it just the candidates?
It applies to candidates, this statute.
And so when you were assisting with it,
Follow-up question.
yes, thank you, sir. So when you were assisting the individuals that came to you, they didn't have the same concern for PACs, since they also have to have treasurer's report?
I believe on the interim committee, we testified it would have, what we preferred is both statutes would change, candidates and the one for PACs and parties, but the individuals pushing this only asked us to do it for candidates.
Okay, thank you.
Representative Simmons.
Thank you, Mr. Chair. Thank you, Mr. Barker, for being here. Who are these people?
Well, one of them was, he's a proponent, was Mike Perner, who's a Senate staffer but does a lot of campaigns in Johnson County. Another one was Chad Bettis, who's one of the small subcontractors, I believe he lives in Shawnee, Johnson County. And they had talked to some others that I talked to, and I'm blanking on them right now.
Okay. Thank you. That was my question.
Representative Mosley, did you have a follow-up?
I did. Thank you, Mr. Chairman. So in this, for this bill, if I were to use a mail vendor, so that's who me as the campaign person, I am, let's say I hire Mission Control to do my mail. I'm writing a check to Mission Control. Mission Control may use someone else who is a printer that I may never interact with. They may use someone else who's doing graphic design. So the onus would be on me, the campaign staffer, the person who is running the campaign, to not only I'm hiring this firm to make my life easier, like now I have to go and find out who all their subcontractors are so that I can add them to a finance report when I am writing one check to that firm? Or how does that work in this situation?
I believe it's the opposite. You won't have to know who the sub-vendors are. You just know you gave the check to the mail vendor, and the product or service you got was the mail that was mailed out on a certain day.
So currently, the current law is vague, and the position of the Public Disclosure Commission is that, yes, you now have to go find every sub-vendor of that vendor. This bill is intended to correct that problem, and you would just go to you would just report the vendor that you wrote the check to. Representative Meyer, did you have a question?
No, but if you want me to, I can.
I thought you were trying to get my attention. I apologize over there. Okay, are there any further questions for the proponent? Mr. Vice Chairman.
Thank you, Mr. Chairman. Mr. Barker, I'm somewhat familiar, I'm not my own treasurer, but, I'm a business person. Usually on campaign reports, you're doing it basically by each check, I get a check to, this mail group or something. So, again, you could still do that. It still doesn't present a problem. It's just, they just want more clarity on what the check was for. I'm still not totally tracking with the import of the bill, that it's just more detail on what that vendor did, or how would you explain it?
So right now, Mr. Vice Chair, the statute requires the amount, date, and purpose of the expenditure. And the wording was amended somewhat to say amount, date, purpose, and the product or services that was being paid for. So right now, some campaigns use very generic, overarching terms like advertising without a little more detail.
I see. So as far as whether it was digital advertising or it was a mailer or it was, is that kind of the gist of what the direction this is trying to push campaign reports in?
That was the main idea behind the bill, Mr. Vice Chair, just to give the public a little more information, but it doesn't require campaigns to go into granular detail.
Okay, thank you.
Are there any further questions for the conferee? Okay, thank you very much. So I only have one other proponent listed with written testimony. Is there anybody else wishing to speak as a proponent? Seeing none, I'm going to close proponent testimony. Is there anybody wishing to speak as neutral or as an opponent on this bill? Okay, seeing none, I'm going to close the hearing on Senate Bill 451, and I'm going to open the informational hearing on Senate Bill 394. To be clear, the reason we're doing an informational hearing is that this bill has not yet been referred to us from the Senate, but we may end up taking action by amending this into some other bill. I don't know. We wanted to have a hearing on the bill that's out there so that everybody was fully informed before we took any action. So with that, Mr. Revisor, if you could tell us what this bill is about.
Mr. Chairman, members of the committee, Senate Bill 394 is currently on Senate General Order, so it's not it wasn't above the line today. I have no clue what they're going to do tomorrow yet. What this bill does is it provides the Secretary of State shall monitor all litigation challenging the validity of the signature verification requirements contained in KSA 251124H, and that provides that sub H, no county election officer shall accept any advanced voting ballot transmitted by mail unless the county election officer verifies the signature of the person on the ballot envelope matches a signature on file with the voter registration records, except verification of the voter signature shall not be required if the voter has a disability preventing the voter from signing, and so on. So that's what the current law provides, and what this bill says that the Secretary of State has to monitor litigation challenging that, and if any state or federal court of competent jurisdiction enters a final order or judgment that is no longer subject to appeal, then basically that final order, the Secretary of State shall cause a notice of that final order or judgment be published in the Kansas Register, and if the final order is issued within 45 days of the date from it shall be certified to the Secretary of State, shall cause notice of the final order and judgment, and so on. The bottom line is that the bill would repeal, based on that final order or judgment, the mail ballot election, the advanced voting. So the guts of the bill are all those statutes that are being repealed contingent upon a final judgment saying that the signature verification requirement's unconstitutional.
Are there any questions for the revisor on the contents of the bill? Okay, seeing none. So I have one proponent listed for the bill, Mr. Clay Barker.
Thank you, Mr. Chair. Clay Barker, General Counsel, Kansas Secretary of State. This bill was brought to us, the idea, by our litigation counsel hired by the Attorney General to defend the state in election litigation. And the concept is straightforward. I'm sure you're all familiar with some statutory codes, like several provisions or bills will have a provision that says these provisions are severable, which means if a court were to strike down one of them, all the others survive. Sometimes, not as often though, the legislature will put in an express provision that says these provisions are not severable, which means if a court strikes down one, the entire bill or the entire section of law is stricken. It can't be enforced. Now, the advanced voting statutes in Kansas, that's Chapter 25 Elections, Article 11, there's about 35 laws. It had always been the belief of our attorneys and the Secretary of State that the signature verification provisions for mail balloting were not severable from the rest of mail balloting. That means if you can't verify the signatures of the people applying for a mail ballot or returning the ballot, then you can't do mail balloting, and the federal UOCAV is separate from this. but it was not set out expressly. Now, in Colorado, there was a similar lawsuit to what's going on here in Kansas, where the Elias Law Firm was challenging signature verification. And in Colorado, the court was asked a question of law, the district court, and they said, well, of course, if you get rid of signature verification, all mail balloting stops. And that froze the litigation. It was appealed to their appellate court and their Supreme Court, who both said they didn't respond, which meant they agreed with the lower court, that it's not severable. Case was immediately dismissed. And so the idea behind this bill is to add to the Kansas statutes a provision that says, in case it wasn't already clear impliedly, it is now expressly stated that if a court were to strike down signature verification, then all mail balloting has to stop. And we suggested an amendment in the Senate. And again, this bill was approved by Fed and State. It's not gone above the line. They may amend it on the floor, or perhaps if it gets to the House on this side, the Fed and State is a blessed committee over there. And that is to get rid of the word final. So it's not a final order, it's any order from a court that stops signature verification, then mail balloting stops. The other amendment in the Senate was from Senator Francisco, who asked for the 45-day provision, which essentially means if we're within 45 days of an election, so people are already asking for mail balloting, it's starting to gear up. If the court were to put an injunction in that 45-day period, the election would still go ahead, no signature verification, but with mail balloting, but the statutes would be struck or frozen right after the election. And that's the essence of the bill, Mr. Chair. I can argue all day about the value of signature verification, but I won't. That's not up here because signature verification already is the law.
So I want to make sure I understood what you just said. So the 45-day provision was added in the Senate committee?
Yes, Mr. Chair.
Okay. All right. Are there any questions for other questions for the proponent? Okay. See, well, you were so close. Mr. Vice Chairman.
So Mr. Barker, again, just to clarify this, it would have to be a rejection of the entire signature verification. I mean, are there any sort of nuances if it's only like a partial rejection of signature verification? I mean, is there any such, it's pretty much an all or nothing question, correct?
Mr. Vice Chair, I think signature verification is all or nothing. Either we can do it or we can't, and the procedures are laid out in a long regulation.
Okay. All right. Thank you. I think that covers me.
Okay, are there any other questions for Mr. Barker? Okay, seeing none. Thank you very much for your testimony. I have nobody else listed as wishing to speak as a proponent on this bill. Does anyone else wish to speak as a proponent? Okay, I also have no one listed to speak as neutral. Does anybody wish to speak as neutral on this bill? Okay, seeing none, I am going to open opponent testimony, and the first conferee I have listed is Mr. Logan DeMond. Welcome back to the committee.
Thank you, Mr. Chairman, members of the committee. My name is Logan DeMond, and I'm the Director of Policy and Research at the American Civil Liberties Union of Kansas. We're a nonprofit, nonpartisan organization that works to protect and strengthen the civil rights and liberties of all Kansans. And we're here today to oppose Senate Bill 394. As I noted in my written testimony, this bill threatens to disenfranchise voters twice over. First, by relying on signature verification, which has a history of rejecting legally cast ballots and denying folks their constitutional right to vote. And second, threatening to eliminate mail-in voting altogether if the courts intervene to protect that right. Put simply, this bill attempts to throw the baby out with the bathwater. I'd like to begin by addressing who signature verification laws most affect. We're talking about elderly folks, those who are disabled, women who change their last name when they get married or divorced, those who speak English as a second language, and those who are voting overseas or military voters. And I'm not just arbitrarily making these claims. Litigation has borne this out over time. These lawsuits are brought not to attack election integrity, but to protect lawful, eligible voters from subjective and inconsistent signature verification laws that are implemented without proper and uniform notice or procurement procedures. The most egregious component of this bill, however, is the way it ties litigation to the full-blown repeal of mail-in voting. Thousands of Kansans rely on voting by mail for a variety of reasons to exercise their constitutional right to vote. And this bill threatens that right. By passing this bill, you're not only jeopardizing the future of mail-in voting in Kansas, but you're putting the courts in an impossible predicament. either uphold the fundamental right to vote or turn a blind eye to the flaws of signature verification. For these reasons, Mr. Chair, members of the committee, on behalf of the ACLU of Kansas, I respectfully encourage you to oppose Senate Bill 394 at the appropriate time. I will stand for questions. Thank you.
Okay, we're going to go ahead and have all the opponents testify, and then we will open up questions. The next conferee I have listed is Ms. Melissa Styler.
Hi, everybody. Good to see you all. My name is Melissa Styler. I'm the Advocacy Director for Loud Light Civic Action. In particular, we are concerned with mail voting because of the constituency that we represent are young Kansans. We've got over 16,000 supporters in the state, who ask us to come and speak on their behalf. So, disclaimer, like everything I will talk about today is all public record. I know that in the Senate hearing, there was a lot of kind of question about what litigation looks like and what the constitutional right to vote in Kansas really covers. So I wanted to just clear up some stuff with information that's agreed upon by both the state and plaintiffs in these lawsuits. This is fact. This isn't my opinion. So I'll just dive into some of that right now. So the Colorado law is different, by the way. That's something I know that's talked about. The Colorado law and lawsuit were about if signature verification is considered a constitutionally protected proper proofs. In Kansas, this has already been ruled on. So for some background, in the League of Women Voters of Kansas versus Schwab, the Supreme Court already ruled on this issue. But Justice Stegall, in his opinion, explained, in designing a process of providing proper proofs, the legislature still must comply with other constitutional guarantees, such as those of equal protection and due process. So in this opinion, the Supreme Court has directed the lower courts to look at, first of all, does the signature requirement achieve reasonable uniformity on objective standards? Second, they're looking at, does it provide reasonable notice of defects and the opportunity to cure? So again, I'm not going to opine on what the courts might do, but I'll tell you that some of the things that they're looking at whenever they're making their decision, so that way maybe you all can use those things to make your decision as well. So one of the first things that you might want to look at is, does the state have adequate legal representation? The law may be perfect, but if you've got lawyers in there who are fiddling about, then it might not go your way. And so this is something that you might want to consider as you're thinking about, who the Secretary of State is working with, who the Attorney General contracts with, because I know that in this case, and again, this is public record, in the state's motion for summary judgment, they submitted material that was generated using ChatGPT, which is a big no-no, right? You're not really supposed to do that. And as proof that there's substantial mail voter fraud, the evidence that was offered is the Attorney General's office directed the courts to search voter fraud topics on the Heritage Foundation's website. And that's some of the evidence that they've provided. That's not all of it, but I'm saying, do you think that that's adequately representing you all? Whenever they're actually looking at the facts of how signature verification is being applied in Kansas, and again, this is not my opinion, this is what is agreed upon by both the state and the plaintiffs, through things like the uncontroverted facts on the case, depositions, etc. They're looking at things like, are local election officials good at signature verification? Are they enacting the law the way that you want them to be enacting the law to make sure that this is actually making for more secure elections? Unfortunately, no, they're not very good at it. The court records show that when 3 county election officials were asked to engage in the signature verification process while being deposed, all 3 of them, except forged signatures, all of them, and 2 of them rejected legitimate signatures. The former Johnson County Commissioner described this process and kind of how they do this amongst counties as a judging art or judging a pie-eating contest. To say it another way, a completely subjective experience. Are the counties collecting enough signatures for them to even be able to do this, even if they were incredibly well-trained? Not consistently. Court records show that the practice of collecting signatures to use for verification, they varied greatly between counties. The grand majority of them had very, very few signatures to even compare whenever they're matching. For example, the Riley County Clerk testified that the overwhelming majority of voters had one comparator on file for the 2024 general election. And every single ballot flagged for this issue had no advanced ballot applications on signatures on file for comparison at all. So I understand signature verification is an all or nothing thing. So is if you get the freedom to vote. Your vote doesn't partially count, it either counts or it doesn't count. So are there safeguards in place to make sure that eligible voters are not having their freedom taken from them because the government isn't good at its job, right? So is there safeguards to protect disabled voters from this happening? I know that this law talks a little bit about that because there was a lot of confusion and lack of clarity around who has to sign, and how do they track and deal with signatures of people who are older or people who have disabilities or whatever, because it doesn't just say, like, can you sign? It says, is it consistent, right? How do they track that kind of thing? That's a little bit addressed here, but not in any substantial way that it would resolve the issue, because there's currently no standards to deal with this in the signature verification law or in rules or regs. There's no process to make sure that they're tracking that disabled voters are not being wrongfully rejected because of this. The standards for how that exemption for disability should apply, there's just nothing. There's no information about this anywhere. You know, perhaps whenever this law was passed, it could have been fleshed out a little bit more to prevent some of these issues, but it was passed with no information about this. So your local government officials, whenever they're trying to apply it, are having a pretty rough time. So again, what is put in here is maybe a start, but it's certainly not enough to actually prevent disabled folks from having their ballot rejected wrongfully because of this law. Now, the other thing to look at here, and there's many other points, but you know, it's like 100 or so pages of court documents per thing, so I didn't want to go too deep into it, but I wanted to talk through, is it even possible, if your signature is rejected, to fix it, to have your vote count? Sometimes, not always. Again, the state has acknowledged this to be the truth. This isn't up for debate. They have agreed that there are eligible Kansas voters who have been disenfranchised because they were never notified that their signature was rejected. They were never notified that it was inconsistent. And some folks who were notified, there's no timeline for when the notification goes out. There's no requirements for how quickly county clerks and election commissioners have to deal with this. And so oftentimes, this is an administrative task. They would send it out by mail. That's how people are often notified on this issue. As we know, the mail is slow, so they wouldn't even receive the letter until after the county canvass had happened. So there would be no opportunity for them to ever go in. Furthermore, curing this process, you know, the right to due process, the right to make sure that you can prove that your vote should count, is also done very inconsistently. I think that this has been resolved, but there's, again, no regulations or rules or anything about standardizing this process. And so Johnson County used to require, up until just recently, used to require people to go and verify their signature in person. If you are voting by mail because you cannot leave your bed, how are you supposed to do that? And so, I mean, these people are disenfranchised because they couldn't overcome bureaucratic red tape that is not making our elections safer. Now, if signature verification, again, you will have the constitutional right to use that as a proper proofs. I believe that you want this to actually be something that makes our elections safer and more secure. Therefore, we have a responsibility to make sure it is working. And so, rather than, if the government isn't doing a good job, County clerks are not trained. They don't have enough resources. There's not enough time to resolve the issue. Perhaps your attorneys are doing a bad job representing you. Rather than to punish every single person who has to vote by mail by eliminating that right altogether, is it not a more reasonable thing to just hold the government accountable, to do a better job, to pass more thorough laws, to fund more training, to make sure that the systems that you all want to be put into effect actually function well? Is that not a far more reasonable thing to do? So you have the power to enact signature verification, even if the courts strike it down, because, again, the Kansas Supreme Court has ruled that signature verification is constitutionally allowed. It is protected. It is a proper proofs. What the question is do you want it to be done well in a way that does not take away people's constitutional freedom to vote? Or do you want to just take away mail voting altogether? Because that's what this bill does. I'd be happy to stand for questions if you have any, but thank you so much, and I hope you take this into consideration.
Okay, I don't have any other opponents listed. Is there anybody else wishing to speak as an opponent? There are written opponents, but I didn't have anybody else listed to speak. Okay. Committee, any questions for the conferees? Representative Meyer had your hand up first, and then Representative Simmons.
Thank you, Mr. Chair. I do have a question this time. I'm not sure which one of you it would be for, so whoever has the most complete answer, but could someone kind of walk me through what happens during the signature verification process, how they do that? It seems like they would just simply be looking at it with their eyes, and we don't have anyone who is necessarily a signature expert on staff at the clerk's offices or anything like that. And the reason I'm asking is because, for instance, I just got divorced and I have the opportunity to change my name back to my maiden name, right? I haven't signed that name in over 25 years. And so I have no idea, first of all, what they would compare it to, since my previous name, is my current name. And second of all, how they would do so if, throughout having to re-sign my name, learn how to sign my maiden name again, I would be, it would obviously change. So how do they go through this process?
Is it on? Oh, there we go. I don't want to just speak off the cuff because of, in case I miss something, I don't want to misspeak here. But the process is very well detailed in the court documents, and I'd be happy to follow up this evening with that information. Perhaps the Secretary of State would be more well-suited to talk about it. I do know that basically it's a video, and but no, there's no experts on staff. It's all in-house training.
Representative Simmons.
Thank you, Mr. Chair. I'm particularly interested in how this may impact individuals with disabilities or maybe health complications. I don't know who would be best to answer this question, but as I was listening to testimony, I thought about my dad, who had an absolutely horrific stroke and lost the ability to write altogether. So let's say that he then goes to exercise his right to vote, but due to the stroke, he's unable to match his previous signature. At any future point in time, what might a relief process look like for that?
Well, there's nothing written that would describe what that actually looks like in current law. So it's up to your county in a lot of ways. Now, in current law, there is an exception, but again, how do they track that? How do they follow up with that? There's nothing. There's no standardization for that process.
If I may, that's very helpful. I very much related to the first question. I'm concerned about in your testimony. Hang on while I pull this back up. That people don't even get notice that their ballot was not counted. So let's say we change the law in this way, and sorry, Dad, but I'm going to continue to use you as an example. Let's say my dad goes to vote, his ballot is thrown out due to a lack of a matching signature. I'm understanding this correctly, that there's a chance he would never know and may continue to vote in election after election, not realizing that his ballot is being thrown out every year because it didn't match.
Oh, yeah, this isn't hypothetical. I mean, I appreciate the personal connection, but this actually happens. This has been proven to happen, that some people just don't get told. And if they do get told, the mail is slow, there's no format, timeline for when they need to send this letter, how quickly they need to receive this letter, et cetera, et cetera. There's just no standardization. So it's, again, kind of, I'm very, 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 very sympathetic to our local government officials, especially considering that the legislature doesn't fund any of the mandates that they put on them. They're trying hard, and often elections offices are deeply under-resourced. If we want them to do a good job, we need to make sure that they have the support, training, and resources to do a good job. We need to give them clear guidelines. We need to make sure that they're not just guessing, right? Because especially in most counties, county clerks don't just do elections. They have a whole other job. And so what can we do to make sure that they're set up for success? And right now, no information about how to deal with this, no timelines, no best practices. That is not setting them up for success.
Thank you.
I'll just stay up here and...
Are there any other questions for the opponents? Okay, so Ms. Styler, are you in support of or opposed to signature verification of ballots, mail-in ballots?
If there's no unconstitutional disenfranchisement of folks, then I have no issue with it. I'll say that there's not a lot of evidence that it actually creates more security in our elections. But if there's no harm of disenfranchisement and it's done well and it's not a burden on our clerks or on the constitutional freedoms of our citizens, then I don't particularly care.
Okay, so you just said that you don't see how signature verification in any way better secures our elections. I'd like to talk about a specific case. We just heard a bill to do away with mail-in ballot only elections. And we heard from conferees that there are a good number of people on our voter rolls who either don't live at the address that they're currently registered at or don't live at all because they're dead and they've never been taken off the voter rolls. So if we just send mail-in ballots to every single human who's on the voter rolls, whether they live there or not, whether they're alive or not, and it shows up at a house and somebody else is living at that house now and they get that ballot and we don't have signature verification, how do we know that the actual registrant for whom that ballot was intended is the person voting that ballot?
So I can appreciate the hypothetical. I don't typically...
It's not a hypothetical. We do mail-in ballot elections all the time.
But the reality of this process that has been happening for a very long time is that in an expert witness report, it was found that the overall rate of voter fraud since 1982 in Kansas as 0.0000092%, and that there's no evidence presented by the state that shows that any fraud has been prevented through signature verification in Kansas.
Ma'am, I'm going to ask you to answer the question I actually asked. We have signature verification right now, and so somebody can't send in a ballot that's not their own because their signature is verified. How would we know that? I'm not saying what is the total number of fraud right now because we have signature verification right now. How would we know that the voter voted that ballot if we don't require them to sign the outside of the envelope and then require the clerk to verify that that signature matches the signature on file? What would be your alternative mechanism for making sure that nobody's voting a ballot that's not theirs?
So if you would have let me continue, I was going to answer your question because I heard you. The Secretary of State and General Counsel for the Secretary of State's office, Clay Barker, have both testified to the court about this very issue. Kansas election law offers a lot of additional safeguards, a lot of them. You could do more things that I could send you additional examples of things specific to mail-only ballot elections. Beyond the list the laundry list of things that have already been presented by the Secretary of State's office and the Attorney General's office, as ensuring that mail voting is safe and secure, regardless of the fact that signature verification hasn't always been, this particular kind of law hasn't always been put into place ever since 1982. Despite whatever, you could, right now you have to put driver's license numbers on your advance ballot request form, or you could do things like requiring a government ID number on advance ballot request forms. There's a lot of different types of things, and I'm not proposing that right now. I'm saying that those are some of the options that have been offered by the Secretary of State's office. But again, I'm not saying get rid of signature verification. And so I don't really want to argue a hypothetical. I want to uplift the reality that the current practice of this is arbitrarily disenfranchising people, is taking away their constitutional freedom to vote.
So you just said that the question that I was asking was in reference to the statement that you made standing up there at the podium that signature verification does not do anything to better secure elections. And when I asked you, the question I asked you was about mail-in only elections. You don't do a mail-in ballot request for a mail-in only election. So I'll ask the question again. If we're not going to do signature verification, what would be the mechanism to make sure that the ballot is being filled out by the person for whom it is intended, not by somebody else?
My position on this bill right now is not to overturn the entire signature verification law, so I'm not prepared to make that argument. I am saying that whenever all three of the people who are charged with doing this in counties accept forged signatures, it is not making sure that our elections are safer. If we would like for this law to be done well, to make sure our elections are secure, then we should make sure that it's actually done well and that it's actually helping with security. My statement up here is that I haven't seen any evidence and that the state has presented no evidence that this makes our elections more secure.
Representative Bergkamp.
Thank you, Mr. Chair. Just two quick questions. One, do you know how many ballots were rejected because the signature didn't match?
I don't remember off the top of my head, but I can follow up just right after this hearing.
Yeah, I'd just be curious because it sounds like from testimony it might be a significant amount, but I just kind of want to get a number on that. And then second, if I might, so we're talking about people mailing ballots back in but then not being counted. I believe there's a place online you can go to verify that your ballot has been received. Is that not correct?
So, sort of. The only county in the entire state of Kansas that has live ballot tracking is Douglas County. Everywhere else relies on manual data entry. It is often very, very out of date and not a reliable source for people to actually use. In fact, because outside of legislative life, what I usually do is I help people vote. Not who to vote for, just making sure that you vote, making sure you understand what ID you need to bring, where your polling place is, that kind of thing. The number one question I get is, it doesn't show my mail ballot is received. Does this mean my vote doesn't count? That's the number one question I get.
And just to follow up, so how long would that be after they mailed it in versus it not being?
It's entirely county dependent because, again, it's a manual entry process. It's like they update the spreadsheet, they submit it to the Secretary of State's office, the Secretary of State's, I'm sure that Clay or Mr. Barker can describe this process a bit more eloquently than I, but it's a manual entry, so it's entirely dependent upon how quickly they enter it.
Okay, thank you.
Representative Mosley.
Thank you, Mr. Chairman. First, I have a couple of questions, if I may. It's been mentioned that if they've received a mail-in ballot, someone can open that up and fill it out if they want to, and then potentially sign that person's signature. First, is opening someone's mail a crime? Is that like, it's a federal offense to open up someone's mail. And so because that's a federal offense, what is at the more risk of disenfranchising voters? That one person who is opening up someone's mail who's already committing a crime, or a bill like this that makes it where someone who might have, like my dad also had a stroke and his signature significantly changed. My sister Sydney was the only one who could do his signature properly, but that's a different story. Got her, a lot of permission slips got signed. What is more at risk of disenfranchising folks? Someone who is already committing a criminal act, which they would go to jail if they were to be turned in, or us having a signature verification that potentially makes it where a lot of people don't get an opportunity to vote?
Yeah, that's a good question, because, you know, oftentimes whenever we're having election security conversations, there's always kind of a give and take, a cost-benefit analysis about the types of laws that you all enact. Frequently, proponents of what I would call like ill-thought-out measures often say, well, one instance of voter fraud is too many because that eliminates one person from voting. So let's pass a law that disenfranchises 30,000 people. 1 versus 30,000 people, right? Like, I agree. Every vote does count. And so we have to really look at the cost-benefit analysis of this. And so again, we have this hypothetical. Hypothetically, the courts will overturn the previous Supreme Court's decision that, you know, signature verification is unconstitutional, but also that's not what the bill says. The bill says that if the law as it stands and how it is enacted right now is ruled unconstitutional, then it would eliminate mail voting for everybody. You know, on the hypothetical that the mail-only ballot election that had the 0.0000092% possibility of fraud in it, you know, again, according to expert witness reports, you know, is it that, or is it the tens of thousands of students who aren't voting in their home district and have to vote by mail? Or the many thousands of disabled voters who literally cannot do anything other than vote by mail? You know, what about me? Whenever I was going and caring for my mother-in-law, she was dying from cancer, and I had to vote from Florida. Do I no longer have the right to vote? Or do I have to choose between caring for my family and my freedom to vote? You know, that's the kind of real question that you're asking with a bill like this. And so, like, heck yeah, I would say that the many, many, many people who depend on voting by mail, they probably equal a lot more than a hypothetical, you know, already criminal act of opening somebody else's mail, filling out their one ballot, you know, and what widespread instance is this happening? There's been no evidence of this. You know, I just like to operate on what do we know to be true.
Mr. Ranking Minority Member, did you have a question?
I did. Thank you, Mr. Chair. I'm going to give you a break and bring up Mr. Damon, because I don't get to ask you enough questions. So I want to follow up on a question the chair was asking in the previous conferee about alternatives. And what concerns me about this bill is that if signature verification is thrown out, mail-in ballots, elections are thrown out as well. So do you have alternatives or anything we can do to make sure that this may be a reform of some sort of nature so we can continue to offer mail-in ballots?
Mr. Chair, if I may, thank you, Representative, for the question. I think it's important to acknowledge the flaws of signature verification, but also recognize that reform is the answer and not repeal. And what this bill is doing is tying litigation to the repeal altogether. What I would recommend, what the ACLU of Kansas would recommend, are uniform, consistent standards for signature verification processes across the states, that we know these steps are being followed. And again, I would just reiterate, reform is the answer, not repeal.
Mr. Chair, one follow-up, if I may. So you and I have talked, and I've challenged you on this, on the word disenfranchise. And could you give us an illustration of what that means, such as senior citizens, you know, or some example, disenfranchisement, tell me a little bit more about that so I can explain it to my constituents.
Mr. Chair, thank you for the question, Representative. I think the instance that was pointed out by previous representative about a disabled family member. When we repeal mail-in voting, we're not just talking about, okay, you have to come in and vote now. That person who cannot go to the polls now cannot vote altogether. That is what we're saying. We're saying this is disenfranchisement. For those folks who cannot make it to the polls, those folks who cannot come in to verify their signature, this is disenfranchisement to the highest degree.
Okay, are there any other questions for the opponents? Okay, I have a message that the Secretary of State's office has an answer to some of the questions from the conferees, and so if he's willing, I'd like to call back up Mr. Clay Barker to answer some of the questions that were asked. Please go ahead.
All right, Mr. Judge, just to make 3 points. First, the regulations that Kansas adopted for signature verification exceed that of every other state in the country. They were designed to make sure they met the criteria that every court that had ruled on signature verification established. And I'd put our system up against any other as being pro-voter. And just to let you know, in 2022 and 2024 together, there were about 300,000 mail ballots. Only 224 were eventually rejected because the voter didn't come to cure the ballot. And that's because our system requires 2 people to say the signature doesn't match. Then you have to make multiple attempts by email, telephone, personal visits to let the voter know their ballot has a problem, and that all has to be recorded at the county level so you can track it. And my last point is signature verification does not apply to people with disabilities. That's why you check the box on the envelope. As soon as that's checked, I got assistance with signing or I can't sign consistently, signature verification is not done. So that was put into our regulations to make sure the disabled were taken care of.
So everybody wants to badger you, so I want to make sure I heard exactly what you just said in that last statement. So we heard several of the opponents say that there's no clear standard for what counts as disabled and unable to sign. You said that you've just said here that the only standard is they check a box saying I can't sign consistently, and then that's it. Is that correct?
If you check the box on the outside of the ballot envelope that says that the voter cannot sign consistently or needs help signing, then that tells the county to not apply signature verification procedures because the signature probably won't match. And I will concede that with 105 counties, you're probably going to find someone that doesn't follow the regulation precisely, but that should not invalidate the statute and the procedure. It just means perhaps more training or better management's needed.
Mr. Ranking Minority Member, did you have a... Okay, Representative Mosley, did you have a question?
I'll talk to you offline. Okay, thank you.
Representative Simmons, and then the Vice Chairman.
Thank you, Mr. Chair. Thank you. That's all extremely helpful. So if all you have to do is check a box, how do you guarantee people aren't just checking the box because they're lazy? I mean, is there any verification of a need for that accommodation?
Representative, many people who are permanently disabled are on the permanent advanced voter list, so they've already got a doctor's notice saying they're disabled. That doesn't necessarily mean they can't sign consistently, but that's an indicator.
If I may ask a follow-up. So then, I'm going to keep using my dad as an example. Let's say he has his stroke in, I don't know, September, and would he have to then prioritize going in to get that on his record, on his voter record, that he was unable to, that he had an accommodation?
If the voter was requesting to be put on the permanent advanced ballot list, they just need the note from a medical provider, and then they send in the application. They don't have to personally appear.
I think I understand the question you're asking. You just said that all they do is them or the person filling out the ballot for them, because they can't fill it out themselves, checks the block that says they can't sign or can't sign consistently. They don't have to go in or fill anything out or do anything in order to not have their signature verified, correct?
The way the regulation's written, no, they don't, Mr. Chair. It's the last provision of the regulation says does not apply to those with disability.
Thank you.
Mr. Vice Chairman, and then the Ranking Minority Member.
Thank you, Mr. Chairman. Thank you, Mr. Barker, for coming back up to explain some of this. You made a comment that you said actually, in actual fact, that Kansas has, some of the sort of higher standards or highest standards in how they accommodate folks, on mail-in votes as far as voter signature clarification or, verification. Can you elaborate a little bit? Like, what do we do more than what other states do that you would consider have a more inferior standard?
Mr. Vice Chair, probably the easiest is that if a voter fails to sign the ballot as opposed to just an inconsistent signature, the courts have said you can reject that ballot straight out. Kansas requires the county to notify the voter they failed to sign. They can come in and sign it.
I see.
That's probably the easiest one to explain. The other is just the number of you need 2 staffers to check, the multiple attempts to contact the voter that the voter has up until the day before the canvass to get the ballot cured. We tried to make sure we met or exceeded the standards set by every court that's looked at this. And we've been criticized because some voter integrity people think we've gone too pro-voter as opposed to not pro-security enough, but we're satisfied with our system.
So, if I may, you mentioned at the end of the day, this would have been in the November 2024 elections, that there were a total of 224 votes of mail-in votes that actually, were rejected in the end, or didn't pass muster, I guess would be this. And how many total mail-in votes were there in that election, roughly?
What I was told by our election team was between the 2022 and 2024 election cycles, that doesn't include the local in 2023, there was about 300,000 mail ballots. I don't know how many were initially flagged as inconsistent or missing a signature, but in the end, about 224, plus or minus a handful, were eventually not counted.
If I may, Mr. Chairman, so you're also saying, some of the criticism about certain, county clerks maybe not being totally on target 100% with correctly identifying signatures. So if they did red flag somebody's signature, current statute or current regulation would be that they have to get a second person to come in and also do the comparison, and then they have to notify the voter, and the voter has until the canvass, which is 10 days to 2 weeks after the election. Is that, can you kind of elaborate a little bit on that?
You summed it up correctly, Mr. Vice Chair. So as soon as the mail ballot comes in its process, which could be 2 weeks before the election day,
okay,
and if the signature looks inconsistent, a second staffer, and they have to go through training, and it's not KBI signature verification level, but they've been trained about what to look for, and they both agree that the signature it's not consistent with the one on record. And by record, I mean every signature in the system since the first registration on, and I think Representative Meyer's question, if someone changes their name, then they have to file a new voter registration form, and they'll have at least one version of a new signature. And then they have to the election staff have to attempt to contact the voter by writing them by first-class mail and attempt to phone call them if there's a phone, and also email or personal visits to the house if they can do that. And some small counties, they actually take the ballot back to the house and say, is this your signature? And then the voter has up until the canvass to cure the signature or provide a signature if they forgot to sign.
Just to elaborate on this, signature verification, I guess I wonder, has there been any sort of notion of improvements in signature verification? I mean, is this something kind of like an AI type of procedure that you would, conceivably go to something like that, or has that been discussed in the broader world of elections?
Mr. Vice Chair, the regulation allows a county to use, we didn't call it AI, but automated signature verification software, if they choose to do that. It can be kind of expensive, and it would be the initial screening of the signatures, but then 2 people have to look at it and say, yes, we agree, the signature on the ballot is inconsistent with what's in our database.
Okay. One final question, if you don't mind.
Okay, yeah, one last question, then there's a lot of other people want to ask questions. Go ahead.
What is the current legal status of our signature verification? It's in the courts, or what has happened to it right now? That was my final question.
Back in 2022, Mr. Vice Chair, when 251124H was added to the code, there was a lawsuit filed challenging multiple provisions that were enacted that year. That's the case that went up to the Supreme Court. And the Supreme Court, if I can summarize their opinion, said essentially signature verification is okay, sent it down to the district court, and said you must ensure that equal protection and due process are being met by the Kansas procedure. So it's been grinding through discovery. You've heard from some of the opponents about the lawsuit and all the information that's coming out, and there'll probably be motions for summary judgment coming up, and then we'll see where it goes from there.
Mr. Ranking Minority Member.
Thank you, Mr. Chair. All right, so Mr. Barker, this is not a gotcha question. I'm just working out my process here. So you state that the state has, you would put our signature verification system up against anybody else, and it sounds like it's first rate. And you also gave the numbers that out of 300,000 ballots over 2 elections, 224 were thrown out. So it sounds like we're really thorough on those 224 that got thrown out. But it also, if I have a longitudinal data set like that, it also brings up the question, we are the strongest at doing verifications, and these are the we only had 224. So my question would be, one, why do we need signature verifications if we've shown there's not really an issue? And the second question, see how I did that? The second question is that you have your choice. They're going to throw out signature verifications. We can't do that. Or do we throw out mail-in ballots? So if the courts come back and say, no more signature verifications, are you willing to throw out mail-in ballots even though it's been proven? So the first question is, do we really have a problem that we need signature verification? Second one, which one would you prefer? Signature verifications or mail-in ballots?
Mr. Chair, or Mr. Ranking Minority Member, for the
tell me what you want.
The first question, it's hard to say about the amount of fraud if we didn't have signature verification. There's a chance you could have a lot of it, but the signature verification itself prevents it from happening. Signature verification also has a second purpose, is it gives the public confidence in the election system. So even if there wasn't fraud, the fact that we have fraud preventions makes the public feel the system is secure. And the public confidence in the election system has to do with the legitimacy of the entire government, that people are elected fairly. On the second question, I certainly hope the court does not enjoin signature verification. It's hard to read a judge or the appellate court or the Supreme Court. I don't think they will enjoin it, and therefore we won't have to, this bill would never, if it becomes law, would never have to be triggered. But if we don't have signature verification, then it's hard to know if the right person is applying for a ballot, if the right person has voted the ballot. I'd rather have signature verification in mail ballots, but if we can't have the basic protections, then we'll have to start from ground zero and create a new system.
Thank you, Mr. Chair.
So those 224 ballots, those are the ones that were not cured. There were more ballots that the signature didn't match, but the voters came in and cured those. So 224 is just the number that couldn't be cured.
That's correct, Mr. Chair.
All right, Representative James.
Thank you, Mr. Chair. So my question is, and it caught my attention, and it has little to do with what we're talking about other than mail-in ballots. You said they were opened prior to the election, 2 weeks prior to the election, mail-in ballots?
Kansas, like most states, and when mail ballots come in, they're first processed. So the outside of the envelope is checked, the signature is checked, everything matches up. This person asked for a ballot, it's been returned. And once they've been processed and approved, then they're open and put in the tabulator well before Election Day. That's why the first iteration of numbers on election night are the mail ballots and the early in-person advance voting. There's no running total kept by anyone until it's run on election night.
So there's, I want to channel my inner Brian Caskey here. So there are as many ways of doing this as there are counties in the state of Kansas. Some counties leave them in the envelope until election night. Some counties take them out of the envelope, flatten them out and stack them, but don't count them. Some go ahead and run them through the machine. So it's really, it depends on the county.
That's correct, Representative.
All right, thank you, thank you.
And that's why in some other states that didn't allow that, you didn't get the mail ballot reports until 5 or 6 the next morning because they had to process them on election night.
Representative Mosley.
Thank you, Mr. Chairman. And I think my representative from the ranking minority member kind of touched a little bit on my question. Okay, so you said 300,000 people voted by mail, and you said 224 weren't able to be cured. And we are arguing about potentially, if we get rid of signature verification, that we need to stop mail-in ballots because of the potential that one person committing a crime could potentially vote in an election. And so my question is, what gives people, would you think that us stopping mail-in ballots for one person potentially committing a crime, would that actually, like us potentially like stopping 300,000 people from voting, would you think that that would give people more confidence in our election system or less confidence in our election system? If you potentially, for 300,000 people, 224 not being able to be cured, I'm not going to do the public math for that, versus one person, hypothetically, who is a criminal committing a crime. What gives us more faith in our electoral system?
Representative, I think the fact that we have security on the mail ballots, because mail ballots is controversial amongst some parts of the population, that the fact that we have the security gives them confidence in the system, and if they were to hear the security's been removed, then they would lack the confidence in mail balloting, and I hope we never have to cross that line. And this, again, would not apply to the UOCAVA and the military ballots. They have a separate system, and I think a lot of voters that vote by mail could find alternate ways of voting, not all of them, but they could find in-person voting. So this is really just a message to the court saying signature verification and mail balloting are so inextricably intertwined, you can't stop one and expect the other to go on.
All right, are there any other questions for the conferee? All right, thank you very much. I appreciate your testimony, or your additional testimony. I am going to close the informational hearing on this bill, and is there anything else for the good of the order? Mr. Ranking Minority.
Thank you, Mr. Chair. Just a point of information, really, is like we've heard this bill. It's not out of Senate yet. If it gets amended in Senate, or will we have another hearing on this? Or are you expecting us to just work it right away?
Well, we cannot work this bill because it has not been referred to us because it has not passed out of the Senate. I wanted to have an informational hearing on this because it might be that it happens on the last, the last day that we're able to hear it, or we may consider amending this language into another bill. And so I wanted to have everybody have a chance to understand what was in the bill and hear from proponents and opponents on the language before we did anything with it. I'm not sure that we will, but we may. Anything else for the good of the order? Representative Simmons.
Mr. Chair, I just want to be really clear. If the Senate takes this up for a vote, and then in their floor process they amend it, will we have an opportunity as a committee to go through the new version of the bill?
The Senate committee has already heard and passed out the bill. If it gets amended on the floor, I don't know what will happen on the floor of the House. I don't even know if this bill will make it to the floor of the Senate. I don't even know if it'll make it to the floor of the Senate. It'll really depend on what date or time that occurred. I can't really commit because the 17th is our last day to have a hearing. If they pass it on the 17th, no, I'm not going to have a hearing on it.
Okay, thank you.
Okay, Mr. Vice Chairman, wow, I thought we were done.
No, I just want to, so Thursday is when we're at Shawnee County. Oh, okay, and I want to make sure we don't forget.
I probably should have went over that. Okay, so on Thursday, day after tomorrow, this committee will not meet in this forum. We won't be meeting on Thursday. We will be having a trip to the Shawnee County Elections Office, and that is not an official meeting. We will not be discussing business. That is just a chance for the committee members to talk to folks that actually do this for a living and hear about their procedures and how they run elections and ask questions, see equipment, do all those things. So that's what we'll be doing on Thursday. On Tuesday, we will be having an informational hearing on the last Senate bill that's out there for elections because it also is not passed out of the Senate or been referred. That's Senate Bill 395. And right now, I do not intend to have a meeting on Thursday the 12th. Our final meeting will be, I believe it's the 17th, Tuesday the 17th, is that correct? That will be our final meeting. I do not know if we are going to work any bills on Tuesday. Right now, I think I want to work all the bills on the 17th because I'm waiting to see what the Senate's going to do, what they're going to send us, what they're going to pass of the House bills. And I want to maintain flexibility in case we have to rescue some of our House bills that are not going to get passed over there. So are there any more comments or questions for the good of the order? Mr. Vice Chairman, we were so close.
With the meeting at the Shawnee County Court, do they have to have a list of names in advance, or?
Yeah, so thank you for asking that. So it's the Shawnee County Elections Office, not courthouse. They're two separate locations. If any of you would like to bring an intern, office assistant, anybody besides a committee member, please get the name to Cheryl as soon as possible because they have to have, because the Shawnee County Elections Office is a controlled facility because they're dealing with sensitive equipment and they've got ballots in there and they just had an election and so a special election. So please give Cheryl the names of anybody besides yourself that you think you may want to bring to attend. Any other questions or comments for the good of the order? See